application is at the instance of the plaintiffs and is directed against the judgment dated January 9, 2008, passed by the learned civil judge under bracket Senior Division Additional Court in Miscellaneous Appeal Number 71 of 2006, thereby reversing the order number 149 dated July 4, 2006, passed by the learned civil judge under bracket Junior Division Second Court Hooghly in title suit number 161 of 1990. The short fact is that the petitioners instituted a suit being titled suit number 161 of 1990 for declaration of title, permanent injunction and other reliefs against the opposite parties before the learned civil judge under bracket Junior Division Hooghly. The defendants opposite parties are contesting the said suit by filing a written statement denying the material allegations raised in the plaint, and they have contended that their predecessor interest got the property by way of permissive possession and the RS record had been recorded in his name by permissive possession accordingly. The petitioners filed an application for local investigation and the opposite parties raised objection against that application. The application for local investigation was rejected. The learned commissioner was directed to investigate the suit properties accordingly. Thereafter, he submitted a report. The defendants opposite parties filed an application challenging that order. That application was rejected. The opposite parties filed a miscellaneous appeal being miscellaneous appeal number 71 of 2006 before the learned district judge Hooghly. Thereafter, the said miscellaneous appeal was transferred to the court of the learned civil judge under bracket Senior Division Additional Court Hooghly. By the judgment dated January 9, 2008, Additional Court allowed the said miscellaneous appeal being aggrieved. This application has been preferred. Upon hearing the learned counsel for the parties and on going through the materials on record, I find that application for local investigation filed by the petitioners was allowed on an application for review filed by the plaintiffs petitioners herein. Accordingly, the advocate commissioner was appointed by the learned trial court to investigate the suit properties as per writ issued to him, and ultimately the learned commissioner submitted his report. From the materials placed in the application, I find that when the learned commissioner started his work for investigation, both the parties participated in the investigation proceedings. This being the position, I am of the view that there is no scope of challenging of the impugned order. The opposite parties contended that the defendant was allowed to reside in respect of the plot number 944, and the question involved in the matter in dispute is whether there is a passage in respect of the Schedule C property. Since the record of rights is silent, the appointment of a survey commissioner, I think, was justified to determine the matter in issue, and in fact, the defendant participated in the process of investigation held by the learned commissioner. Therefore, I do not find any justified ground to interfere with the impugned order. The report of the commissioner shall be the evidence of the suit, and it shall form a part of the record. The revisional application therefore fails to succeed. It is therefore dismissed and over.